pictures sitting at a desk in the office of House Speaker Nancy Pelosi on January 6th was released last night after a federal prosecutor told the court that the government had begun plea negotiations. So where does this case stand now? We are joined by Joseph McBride, who is an attorney for Richard Big O Barnett, and Stephen Metcalf, who is co-counsel. Gentlemen, thank you so much for joining us this morning. The Justice Department said in court yesterday that they've begun guilty plea discussions with you in this case for Richard Barnett. Can you tell us where that stands?
So good morning, and thank you for having us. No formal discussions have ensued or taken place at this point. There has been a preliminary offer that we have conveyed to our client. Our client has zero interest in that offer at this time. So as of now, we are awaiting further discovery from the government, and we are looking to proceed to trial. Should an acceptable offer materialize between now and then we will give it due and proper consideration. But no formal discussions of any kind at this time.
So when is then, as you are looking towards heading to trial here, when do you expect that to be?
As we sit here now, trial is not something that will be in the immediate future. We just ended up getting Richard out on bond yesterday. The next steps now are to actually go to the Capitol and view what is now the crime scene. There are various different investigations that Joseph and I still have to conduct, and hundreds, if not thousands, of videos and documents that still need to be reviewed before we could even talk about setting forth the trial date. And federal courts are not conducting trials at this time as well. So it's going to take some time before we actually have an understanding of when this case could go to trial.
Joseph, what didn't your client like about the offer? Was it too prolonged of a prison sentence? Was it the charge, the severity of the charge? What was it?
Quite frankly, it was all of it. We feel strongly that we have a good case, that we have a triable case. We have felt strongly about the presumption of innocence. We have felt strongly about the Bail Reform Act's presumption against pretrial detention. We are grateful and glad that the Judge Cooper's ruling, he sided with us in terms of the facts and application of law yesterday. And with regard to moving forward, you look at the charge of a violent entry into the U.S. Capitol. Non-violent entry is an absolute defense. We furnished evidence to the court yesterday demonstrative of the fact that his entry was in fact involuntary. So as things proceed, we will begin to pull apart the charges and see what sticks and what don't, and what does not stick. And then at that time, we will be able to make a more intelligent decision about the crimes under which he has been charged.
So you made an argument in court yesterday that raised some eyebrows. You argued that your client calling the speaker, and I am quoting here, a quote, biatch in his note to her rather than a quote, bitch, was less offensive. Do you stand by that argument today?
Yes, we stand by that argument today. But more importantly, the argument was made intentionally as to raise eyebrows to the fact that the government has deliberately mischaracterized evidence since the inception of this case.
Okay, well, let me ask you about this. How is the difference between quote biatch or quote bitch significant at all if the person who wrote the menacing note did so after entering the Capitol illegally, allegedly, and allegedly trespassing in her personal office while allegedly armed with a powerful taser?
So there's a lot of allegedlys in that statement, and I'll just, and
well,
it's a
look,
compound
I will say,
question.
look, I get that, but we have a picture of him. He's in the office. You see the taser. So there's nothing I said that is like out there. These are the things, these are the facts that you are going to contend with in court. How is there a difference between that one word and the other word when you have all of these other factors?
Sure, I'll break it down for you real simple. Anytime a federal prosecutor quotes something, it's got to be accurate. Underscores, bolding, emphasis added, commas, it all has to be done the right way. The federal government does not have the luxury to misrepresent evidence of any kind at any point at any time in court. They've been doing that since the beginning. We've been calling them out since the beginning. We will continue to call them out, no matter how minuscule or how huge, until the very end.
Okay, well, let's talk about this difference, because as part of your explanation of quote biatch versus quote bitch, you cite a definition on a dictionary website that says quote biatch is slang and that it's used as a term of endearment or disparagement. Would you say that your client is a fan of Nancy Pelosi's, or would it be more accurate to say that he would describe her in disparaging terms?
I would say that my client understands that his statements and that the accepting the allegation as true, the note that, for the sake of argument, of course, the note that he is alleged to have left was all made in bad taste. Mr. Barnett is a funny man. He's a jokester. He doesn't have a real clear sense of boundaries. If he could take it back, he likely would, but we can't unring the bell at this point. And I'm going to leave it there.
Okay. I mean, for anyone who has been called a quote bitch, it's not funny. I will just attest to that. I think that any woman, and most of us have been called that, can tell you that. Does your client still believe conspiracy theories about the election?
I have no idea what you're talking about with regard to any conspiracy theories.
That Donald Trump won the election. The whole basis for why he and others entered the Capitol.
Richard Barnett, like millions of other people, clearly voted for Donald Trump during the November election. Richard Barnett, like millions of other people, believed at the time that the election was stolen from the American public. Hence, his heading to Washington, D.C. to exercise his First Amendment right to free speech, to object to what he believed was an improper result. Does he still believe that at this point in time? I haven't asked him, because it really isn't relevant to his case. What's relevant to his case is that he is now he is no longer detained. We will be able to have intelligent discussions with him going forward. We've been systematically denied that opportunity. The conditions under which he was confined were horrific, and he is now out, and we will be able to form an intelligent defense going forward.
In one court filing, you compare what happened in Washington, D.C. on January 6th to Black Lives Matter protests in Minneapolis after the death of George Floyd. How do you square that, especially knowing now that George Floyd's death was murder, that an officer has been convicted for his murder? Is that really a valid comparison?
Sure. So the motion to which you are referring, we explicitly state that George Floyd was murdered by the police on national TV. And his murder on TV provoked a massive reaction. Now, anybody who was alive or
But that actually happened. Joseph, that actually happened.
Mm-hmm.
He was murdered.
Yes, that happened.
Donald Trump was not elected president.
So we acknowledge the fact that George Floyd was murdered. We support the protest, as does Richard Barnett, in George Floyd's name, because they are both necessary and vital to addressing the ongoing issue of police brutality against Black and Latino men and other minorities in this country. Now, we were very sure not to equivocate the experience and the issues regarding George Floyd's unfortunate passing with those of the Capitol situation. However, when you look at 2020, you cannot look at it in a vacuum. There was a stream of protests, some peaceful, some violent, that took place all over the United States of America. Cops were firebombed, police were firebombed, and in those cases, those violent cases, federal courts have routinely let those people out pre-trial. We argued that our client was entitled to be released pre-trial because his participation in the January 6th events was not violent.
Joseph McBride and Steve Metcalf, I appreciate both of you coming on. Thanks for being with us.